Hello, good afternoon, or good day to you, whatever your time zone is. It's a beautiful time here again, another wonderful time of learning, of understanding the real estate market, understanding what real estate entails, understanding everything about real estate, understanding the legal parts and various things like that. And today, I am not here alone today. I have the pleasure of having um, a legal professional, a legal expert, who is going to be talking about property in marriages. She's going to be educating us about knowing the nuances, the intricacies, and what the law says, because it's usually said that ignorance of the law is not an excuse. So you should know what the law says about anything at all. The law does not want to understand whether you're ignorant or not. The law is not emotional. The law only understands logic. And so we just want to know all these fine details. And that's why I brought a legal expert to the house today. Shortly, she's already in the waiting room already, and I'll be bringing her up almost right away so that we can start. So if you are here, if you're in the room already, you can just say hello. You can tell us where you're joining us from so that we can do a shout out to you. Thank you for joining. I can see some people in the room already. Thank you for joining. So you can tell us your name and where you are joining from. A good afternoon to you. Good afternoon, Mario. I can see Mario in the room. Good afternoon. Thank you for joining. All right. Without wasting much of our time, I'll be bringing up Barrister Olarin Oga. Barrister Folarin, it's so good to see you. It's so good to have you here.
Thank you.
All right. Um, I don't know. I know you have a very busy schedule. You've been trying to do this for a while, and I want to appreciate you for bringing out time from your very busy schedule to at least let's have this conversation. And I also want to appreciate what you've been doing, the legal education you have been doing on your social media handles. That's something that many of us wish we have, or many of our parents, many of people in marriages today that they don't have and that they should have. That's why I brought someone like you who is an expert in real estate, in marriage, divorce, and the like. Um, so I'll just allow you to do the introduction yourself to the audience. So just tell us your name and what you do. Then we can go straight into why we are here today.
Hello, everyone. I am Folari Oga, a legal practitioner. I reside in Abeokuta. I practice in Abeokuta. I'm a family law expert. My area of specialization is family, divorce, marriage, child rights, property litigation, registration of properties, corporate law, and what have you. Anything about law, just contact me. I'm your go-to
All right.
person.
And you did not add that you are the head of chambers and templum solicitors. Are you trying to
Yes,
be
I
all?
am I'm the head of chambers and templum solicitors in Abeokuta.
So you brought a big fish to the house today. Thank you so much for joining us
Thank
again.
you.
So yes, let's just go straight into the conversation. Last week was International Women's Day celebration, and the theme was there are always themes whenever we have International Women's Day. But this year's edition was Accelerate Action. And personally, for me, I usually sometimes I'm not so excited about all these themes, and the reason is that I sometimes feel like maybe business as usual. There's little being just probably when you go to the state government, they have events, functions like that. First lady organizes function, Ministry of Women Affairs, and sometimes you don't really see it, the output. I'm curious, what's your own take about this international Women's Day, as regards to the female gender?
I think it's better than it used to be. I can say that for sure. Now female women are being included in many things. You can testify that before they just They just feel okay, women, their primary responsibility is just the home, take care of the home, take care of the husband, take care of the children. Of course, you can be a dutiful wife, a responsible mother, and still choose a career path. And is not looking absurd now if you say, oh, I'm a career woman. They don't look at you now um as, oh, this one does not have time for family. At least it's
Yes.
better than it used to be,
Yes.
and it's gradual process.
All right. I get
Yeah.
that. So it's not like there's a place where we are coming from. Did I say we, where women are coming from, and
Yes.
we should appreciate progress. Maybe not there yet, but at least there's progress. So that's something to appreciate. All right. Thank you very much. And I was reading something. I wrote about it even on LinkedIn. There was a report, a 2023 report from the Ministry of Women Affairs that out of the land owners in Nigeria, only 10% are women. Yeah, out of the, so there are 100 landowners in Nigeria, just 10 of them are women. And I began to search what are the reasons for this. Of course, I saw maybe inheritance, structure in places, patriarchy, even laws. Some people claim laws. So I want to ask you, are a lawyer, are there laws in Nigeria today as we speak that still limits women from acquiring and owning real estate?
Not at all. There is no law limiting a woman from having owning real estate. Do you get? You in Nigeria, in short, we have Married Women Property Law Act. Like, there's a law that says that a woman can have as much properties as she wishes. Do you get? I think it's a stereotype before that, okay, um they subject women to a kind of, like I said earlier, before, women used to be just wives and mothers and just daughters. Do you get? But now women are coming out. That's why maybe at the land registry where they register deeds, you can see maybe like just 10% of women actually own properties. There's a lot of difference now because people are getting more aware that you can actually have a property or properties, streams of properties, as you want as a woman, because everybody has a name, either man or woman. Everybody has a juristic name. Do you understand? So
Yeah.
there is nothing limiting you as a woman to own a property. As much as a man can own a property, a woman can also own a property, because in the eyes of the Lord, we are all human, as it is in the eyes of God.
Okay. All right. Interesting. Okay, thank you for that. At least with that, we are clear that it's not like there's any law limiting women. Women are allowed to, and women should be aware that they are allowed to. Right? And it still aligns to what we were talking about when we talk about International Women's Day celebration. Um, there should be, I think, more education, more orientation out there, so that women don't just assume, because I think there are women that assume that perhaps they can't inherit land maybe where they came from, and that mindset is also limiting them from actually investing in real estate. So we keep doing the advocacy or the education, so to speak. I want us to talk about the marriage concept. Thank God you mentioned the fact that a man and a woman are both juristic um, parties or individuals
Persons.
in the eyes of the law. So that brings me to my next question. What are the legal ways a man and a wife in the context of marriage now can own property?
As you can own a property individually, even while in marriage, you can buy property to your own name as a woman, and a man can buy property to his own name as a man. However, you can also buy together as joint owners of a property. In that case, in the deed of assignment or deed of agreement, deed of conveyance, whatever it is that you want to tag it as, it should be specifically written Mr. Ajala and Mrs. Ajala as purchasers of that property. Do you
Not
get?
Mr.
So
and
they are
Mrs.
jointly,
Ajala.
not Mr. and Mrs. Ajala. Mr. and Mrs. Ajala in the eyes of the law is nothing. Every person has a name. So Mr. Anybody can be Mr. and Mrs. Ajala. But okay, Mr. Funmi Ajala and Mrs. Folarin Ajala own this property. You can jointly own a property. And there are some cases whereby a man buys property or a woman buys property in her own
Yeah.
name, but he or she wants the other spouse to enjoy the benefit.
Okay.
You get? Maybe they contributed money and okay, they just say okay, you do it in your name. They can create a trust arrangement for that. After buying the property, you do the deed. There's something we call deed of trust. In that deed of trust is also a legal instrument. You can create it whereby it will be stated that 70% of the property we bought in so you describe the property belongs to Mrs. Ajala, while 30% of the property as described belongs to Mr. Ajala.
I
So
see.
it doesn't matter whether it was the property itself, the instrument for the property, the deed of assignment or conveyance was in one person's name. If there is another deed of trust, if maybe in case of divorce or whatever, it will still protect the other person that the name does not show in the deed of conveyance.
Okay. Okay. That's interesting. That brings me to my next question because now we are talking about if you already mentioned the fact that maybe a spouse or both spouse are buying a property together, the property should be in both names, Mr. Ajala Yemi and Mrs. Ajala Fumi, so to say. Any other precautions that people should take? Because I'm asking this because I've been privileged to be in probably disputes, not like as a lawyer now, in alternative dispute resolution platform where the woman was, aggrieved because she she and the husband bought the property together. And after the husband, died, the family members came up and said that there are other children and that they should divide that property equally with the other children. And she was feeling aggrieved that she actually had almost equal or even more than equal in the purchasing of that property. And she was not satisfied with that arrangement. What are the kind of precautions that people, either a woman or a man now, because I know it affects both parties, but mostly women are usually take the short end of the stick in our own country, and we should actually take relevance of that. So, what are the precautions that people can take in this instance?
The precaution is that, like I mentioned earlier, arrangement. In that trust, deed of trust, now you will state it that the wife has 70% of shares in it. The husband has 30% of shares in it. So if children now surface after the death of the man, especially if the man did not write a will before he died, the that thing, that sharing can only affect the percentage of the man,
Okay.
because doing
Percentage that
trust
has been
arrangement
agreed
now does not
on the day of the
only
trust.
limit to when you want to divorce or something. Issues like this happen, that even the woman might not know that there is actually a child outside, and when the man comes, they'll say, oh, this is the child, this is this man's child, and you have to give him because he has to be, he is a beneficiary of his father's property. Do you get? So if there
Yeah.
is actually a trust arrangement or a partnership agreement, especially when they have streams of income, streams of businesses, they have real estate businesses. If there is a partnership agreement, it will be clearly stated there that okay, this is your shares in this property, this is my own share in this property. It's the right I have to the right they have is independent now. So if you are sharing, you are only sharing your own part. If you want to alienate, you want to sell your own part, you can sell. But me, I'm not selling my own part, or I'm not sharing my own part. It is still me. So the law protects the right. Even though it is joint, the law still protects it individually.
All right. You know, it's interesting because
Sorry, let me
unfortunately,
add
most,
one more thing that you should, one of the precautions is that in this part
all
of the
right.
world, we really don't take prenuptial agreements serious, but it is good to do that.
Oh, so we have jobs in Nigeria too.
Yes, it's acceptable in Nigeria. If you have, okay, an agreement before you got married, okay, this is
I've
how.
never heard anybody in Nigeria
And
do a prenup.
it's because we have not tested the law in that area. You get,
Okay.
it's because we've not tested the law in that
Yes.
area. So if you have an agreement before you got married and both of you signed, and it is sure, or the court knows that, okay, agrees that both of you were in your right frame of mind when you were signing these agreements, if cases of this happen, you can bring the prenuptial agreement, even postnuptial, like after marriage. When you're in the marriage, you can have agreement that okay, so part of this property is yours, so part of this property is yours. If issues like this arise, you'll be able to know um where you belong, and clear documentation. Don't just say, oh, I gave him 20,000 in buying this property, and our rights has to be equal. No, not necessarily. Let me put it that way, because there was a case that the court agreed with a woman that was saying that the property they bought during the pregnancy of the marriage is property of the marriage, and they have to share it because she added emotional support when the man was acquiring the
Okay.
property.
That would have been my next question. But now that you've talked about it, that's actually emotional support. It's not something we hear often
Of course.
again, because most people, when you say a woman who has not contributed financially, or a man who has not contributed financially to a property that was bought in the marriage, um, I mean, naturally, you would expect that that person does not have any
Right,
stake in
yeah.
it. So, are you saying now that women or men in marriages can lay claim or in parts of claim to some property that they bought within the period when they were married?
That is correct. But you must prove that okay, you actually contributed, no matter how low the contribution is. You must prove that you have actually. But that is people that married under marriage act, that married statutorily, not customarily now.
Okay.
Statutorily.
So now it's a different ball game for people who married in the customary
Yes,
or Islamic law.
yes. Sharing of property, whatever, will affect maybe the custom of their area. They are alike, but we have different cultures. So if they want to share property like that, it will be in accordance with their custom, whatever it is. I think in Igbo, in Igbo, if a man dies intestate,
If a man dies intestate,
intestate means if a man dies
if a man
without
dies without
a will,
a
Right
will,
away. Yeah.
without writing a
without
will,
writing a will,
then
Yes.
the properties can be shared based on the custom of that man or religion of that man. But if it was statutory marriage, I mean marriage conducted in registry, licensed place of worship, you can is property of the marriage that is governed by the Marriage Act. So you can say, oh, when this person was building this property, oh, there was a time that there was no water at the site, and I had money then, and I supplied water at the site. That is contribution. The court will agree with you that that is contribution. The sharing will now be at the discretion of the court, but it has to be equitable.
Hmm. That's interesting. Okay. Talking about this will and the likes. One of the things that we watch, I've seen in Nollywood movies. I don't know if it's practical. So that's why I wanted to ask you now. You
Okay.
see, sometimes a father disown a child that I have disowned you, and because of that, you no longer have any part to play or anything that belongs to me. Now, are you saying is there anything like even disown in Nigerian law? And if there is, can you disown a child and that child does not longer have anything? Maybe when that person dies intestate, like you said, the child does not have any right to the property that person has left behind.
I didn't get
You get
you.
that question?
No, I
All
didn't
right.
get you.
Now I'm saying in the instance of we've had instances of saying a child who probably the father was not pleased with or the parents and he disowned
Yeah.
the child. Yes.
Yes.
So if the parents, perhaps the dad or the mom or the child left a property for them intestate, they died intestate, they didn't write a will. Does that kind of
Yes.
child who has been disowned, does the child have anything that he or she can claim as a child since he or she has been disowned?
Well, in
Well,
Nigeria, it's not
in
known to
Nigeria,
law.
it's not known
I mean, it's
to
not
law.
known that you disown a child. This person is your biological child. It's not maybe adopted, or you just took him from somewhere. It's your biological child. It is your responsibility to take care of the child. So in matter of inheritance or wills, if the man dies intestate, the child that was disowned, quote and unquote, can contest the will, that he should be a beneficiary of the will. And if court agrees with him, they will share part of the will of the man with him, of the estate of the man with him. So, well, tonight, not that we know in Nigeria, disowning is because every child deserves a home. even
Hmm.
even orphans, even people that are at motherless babies home, that is why there is a home, motherless babies home. You can't just see any child roaming on the street.
Okay.
So you can't say, okay, oh, well, it's not recognized under Nigerian law, none that I know of.
So it's just Nollywood.
It's just emotional emotional disownment. You get, it's just like maybe the man was in his feelings or something. But legally, a man cannot like legally renounce that. Okay, I'm no longer your father, but the person still carries your DNA.
Interesting. Thanks so much for that. All right, if you are just joining this conversation, I've been speaking with Barrister Polarin Oga. She's the head of chambers at Templum Solicitors, and she's been educating us about some interesting matters in property, concerning property within the context of marriage in Nigeria. And we've been learning something so far. So if you have any questions, you can ask in the comment section so that before we allow her to go. We spend almost 30 minutes now, in which we can do probably like 45 minutes or less so that she can go back to her work. So if you have any question, you can drop it in the comment section and I would pick your question. Thank you, Barrister Foline, for helping us so far. I want to ask, what's because these are some things we experience, and I'm also sure you see in the line of your job. we had instances of a spouse maybe selling the property that they co-own. Are there legal ways that probably the wife, I don't know why I keep talking about the wife, maybe because that's usually the common
Because the
case.
wives are always at the receiving end.
Yes, yes, unfortunately so. So, are there legal ways that a wife, for instance, can prevent the husband from selling the property that they both own together?
Of course, there is. Like I said the other time, there are ways that you can alienate your own property. There are two things in land law. We have joint tenancy and tenancy in common. Joint tenancy now, we co-own the property. You can't sell it without my consent. But tenancy in common now, you own 70% of shares, I own 30% of shares. You can only alienate your 70% and not my own 30%. Now, in case of maybe they break up or something, or divorce or something, if you want to sell your own share, I have the right to force refusal to buy it. Like, as I can say, okay, you want to sell your 70%, I own 30%, and I can say, okay, take money. For how much do you want to sell your 70%? So amount. Okay, I will pay you. Then it becomes mine. If you have properties as joint owners and somebody sells independently, you can contest it. That sale, that conveyance, it is void ab initio. Well, it could be voidable because you might say you want to ratify the sale. You
Yeah,
understand? So as joint owners, somebody cannot individually transfer interest of a joint owned property to another person. It has to be jointly transferred
be transferred.
with consent. Yes.
So in this case, it is the buyer that will be at the losing end if eventually maybe the wife goes to court and claim a legal rights to that property. It's
Well,
the buyer that
there's something in law that we call purchaser without notice of value. If as a buyer you can establish the fact that you didn't know that, okay, you have conducted your due diligence and you are able to satisfy the court that it is possible for you not to know that that property was jointly owned, the liability now goes back to the person that sold to you. But if the court sees that you can reasonably think or suspect that this property is not an individual that has the property, and you still goes ahead to buy it, then the court does not concern itself with you, because there is actually a reasonable suspicion that this property is jointly owned.
thank you so much. Someone is asking a question in the comment section. I want us to quickly check that. Mario is asking, what about you bought the property before marriage and something happened? Can the wife lay claim in case they are no more together?
No.
Did you get the question?
Property,
Okay.
yes, I saw the question.
Alright.
Properties you bought before marriage are your properties, not property of the marriage. Except if, because there are some instances whereby um girlfriend and boyfriend, or fiance and fiancé, they want to co-own property before marriage.
Boyfriend and
Right?
girlfriend, can they
Yes,
co-own?
they might say they want to co-own a property before marriage. It's possible. But if you did not co-own property with somebody before marriage, you cannot lay claim to it. You can't say, because I am now married to you, I should now lay claim to the properties you bought before I got married to you. There's no amount of evidence that you want to give that you supported emotionally, that would, because you know marriage binds two people together that become one.
Yes.
That is how the Lord sees marriage. So if you are not together, you people might be cohabiting, but if that thing does not bind both of you together as one, you
One.
cannot lay claim to somebody else's property and say because we were dating and he bought a property and I gave him emotional support, and
Hmm.
you can't lay claim to, because except if there was an agreement that okay, before we got married both of us go own this property, that is when you can lay claim to it.
That's actually interesting because it kind of brings me back to what you talked about earlier when we were talking about if a spouse can, through emotional support, have passed to a property. Now, you talked about cohabiting now. There are some people who assumed they have been married. I mean, everybody assumed they already have children who have graduated, they have been living together for years and they have not done anything before the eyes of the law. So now, any property bought within that period, maybe by either of the spouse, it is nothing, those properties cannot be termed as properties of the marriage.
Except if both of you bought it as joint owners.
Wow.
If
Wow.
somebody you bought it in somebody, except you can bring evidence that okay, I actually, this is the amount I paid the vendor, this is the amount, and here the court can say okay, or this is the amount I transferred to this person, and you tagged it in the narration, my own part of payment for so, then the court can is enough evidence to say okay, is a joint property. Because cohabitation is not marriage. If you are cohabiting with somebody does not mean you are married, though it's a presumption, it might be a presumption, but it's a rebuttable presumption. You might be living with me, and you be two people can be living together, and the wife say, the lady says oh we are married, and the guy say we are not married, or people think that they are married, and you will say we are not married though. Of course you're not
Yeah.
married.
Person is
Even
married
if
to
you guys,
herself.
yes, to itself or herself, even if you guys have like 20 children together, it doesn't still amount to marriage.
Eh, that's actually interesting. Let's talk. Yeah. Are you trying to say something? I can't get an audio feedback from you.
No, 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 no.
All right, all right. Okay. So I want to talk about a little bit about writing a will. Most people don't write will in Nigeria. Is is it? I don't know. Maybe it has changed now, but I mean, the last time I read about it, I know most people don't write wills, don't prepare will. Has this changed? And if not, is there still a reason for this? Because it's causing troubles. But I one of the most iconic cases I read at the time was the case of a great lawyer, F.R.A. Williams. You know, up to now, his children are still fighting over his estate up till today. And it's very sad because for someone like someone of that stature, someone of that knowledge, not writing a will, and he's not alone in this. There are many Nigerians who don't write will, and it usually causes problem for their. Is there a reason for this? Maybe that you guys have found out in your research or something.
Well, as much as will is good, it's a personal decision. Nobody can force you to write a will, but it is good to write a will. At least it will prevent the family from fighting after your death. But the thing is that Nigerians, we believe that if you write a will, you're already planning that you will die. As young as I am, I can write a will. It doesn't mean, oh, I write a will, I will die tomorrow. No. But I think that is the fear, or maybe what Nollywood had sold to us. That's what we have consumed without like checking, placing it on balance of a on a scale to weigh what's the benefit of writing a will and what's the benefit of just going, leaving your estate without writing a will. So a person can say, oh, I don't want my children to fight or something. You can write a will and will all your properties, all you have, to an orphanage. So writing a will is not a death sentence, or is not in anticipation that you want to die. It's just the good thing and right thing to do. And if a will is properly drafted, it will save us much stress, much court case. Yes.
Interesting. There's another question in the comment section that I want us to look at from Adeloye Doyisola. He's asking that, can one lay a claim to a property which she owns as little as 10% while in marriage during divorce? I think you talked about it earlier.
Yeah, of course, you can lay, even if it was emotional support, as little as emotional support, you can lay claim to it. But the sharing formula will now be based on equity, and that will be at the discretion of the court. So there's no legal, or there's no format at which you you have to follow to share property of the marriage. It has to be at the discretion of the court that is handling the case.
So at the end of the day, it still boils down to either writing a will, or apart from that, I think there's also what we call trust. Like
Yes.
um, trust is, I think we have not really talked about trust. What are the, is it better than writing a will? Or because one thing that I forgot to ask you, or that I've not asked you, we also have
Yeah.
cases of wills being contested. I mean, normally it shouldn't be something that someone has written, and sometimes it gets to court, and I hear that sometimes the court, changes, or depending on whatever the case may be. So if wills can be contested, that means it's not even foolproof. Is
For
trust
example,
another option? Okay.
the example you made the other time about disowning a child or something, if a beneficiary sees that I did not benefit from this will, like for example an old parent that you have been caring for while you're still alive, and you did not include that kind of person in the will, the person can contest it that I've been a dependent of this person. And if the court sees that okay, it's necessary for you to benefit from that, of course the court will. The fact that you take you contest a will in the court does not mean that the court will grant you your request. So it is a matter of evidence, what you put before the court, because everything the court does, as much as the law mandates the court to look at some things, the court still has discretion over anything brought before it.
Right. Thank you so much. We spent 39 minutes here already, and Barrister Adeloye Doyisola is saying thank you for the insight. And so I want to ask you a few more questions before we call it a
Okay.
day. Let's talk about, real estate now, owning real estate. What are the what are documents that you feel every real estate owner should have? Because Nigerians usually focus on, or when they say documents, people make assumptions of this document and that. What are the documents that you feel, or not them necessarily feel now that according to the law that you should have as an owner of real estate?
Well, for properties, there's something we call deed, and that is the agreement. Agreement, a deed properly drafted by a solicitor, a
Not by
lawyer,
an agent.
not by an agent, not by typewriter at the roadside. In short, do you know that there is a law that criminalizes the fact that a person that is not a lawyer that franked a deed is a criminal liability? Do you know?
Oh wow, I didn't know
Yes.
that.
Now you know.
Well,
It is criminal for you
that's what I always
as a
advise my friends
non-lawyer.
not to do.
Yes, a lawyer should be the proper person to frank a deed for you, a deed of conveyance. So far, you are transferring title. If maybe you and so aside the fact that the law criminalizes a lawyer not signing the agreement or an agent signing agreement, to protect you, the agent or the roadside people might not be able to protect your interest, but your lawyer would 100% protect your interest. So it is best, as you are trying to get a property, the deed of conveyance that you would do should be by a lawyer, and your lawyer should be involved, not just the vendor's lawyer. The vendor's lawyer will always protect the vendor and not you. So both parties should have a lawyer in in the transaction. And if you want to buy a land, especially for the real estate people, number one thing, the most important thing you should do first is search, conduct your due diligence. Because what if you buy a property and in the nearest future you discover that government just want to bulldoze the land? You say, I bought the land from so and now the government wants to do injustice. What if the land had been acquired even before you bought it? Government can acquire land, but should be used for public purpose,
Okay.
and you now went to buy from so it's always good to do your due diligence, conduct search at the land registry or probate registry or court to know if there are litigation on the land, or there are encumbrances, like maybe the person that is selling to you is not the real owner of the place. I can just stand somewhere in Ekpe and say, I own the expanse of this land and you pay to me. If you don't conduct your due diligence, I would have collected your money and run away. Maybe I japa with it.
It's not.
So it is left for you as the purchaser to do your due diligence before getting it. In short, before paying. So far, your agents take you there, you site the property. It is your own duty to conduct the search, and it is a public document. You can check it, go to the apply to the, in short, individuals can do it, go and apply. You can also go through a lawyer to apply to search that property if it is free from any encumbrance.
Thank you so much. Okay. We also have another we still have another question, but I think it looks like we've talked about this earlier from Raji Lydia. He's asking that yes, we've handled this earlier in the conversation, but I don't know if we can handle it, or probably should have to probably go back to
What's
the video later.
what's
What's
the
the
best
best
way?
way for couples to structure property ownership to avoid
Li-
disputes later?
like I said, is either you do joint ownership, whereby your names will be explicitly spelled out in the deed that this property is being bought by you and you, not Mr. and Mrs. Raji. It has to be Raji, Mrs. Raji Lydia Oluwatosin and Mr. Raji Shegun, so that when you're laying claim to it, it will show in the evidence that this property is jointly owned. And like I said, if there is a if there was a case or situation that you both of you contributed money, but it was written in one person, you can create a trust arrangement like I said earlier, or a partnership agreement. Trust arrangement, you explicitly say it that okay, oh, this property is in my name, but I'm holding it in trust for the benefit of both of us, or for the benefit of the other party. Or this person, we did deed of trust, or this person has 70% of the money we purchased the property with, this person has 30%. Explicit agreement solves everything. Always do agreement, put it in writing. It will save people a lot of stress, a lot of talking too much.
That, it, it also reminds me of how most of us are, yeah, because I've interacted with lawyers, and what they usually say is that it's best you have a lawyer earlier, you get a lawyer when you don't need a lawyer. I mean, most of us, we only get a lawyer after there's trouble, after everything has gone, you know. But if you have a lawyer who's
Sound.
guiding you, you won't make all these mistakes. And that's why it's important to have people in your profession always on ground. So thank you for what you have been doing. And thank you for your time so far. Is there any live example or anything that you feel that the viewers can learn from when we round up? Is there any live examples of cases that you handled?
I guess we did not talk about the difference between a will and a trust. It is very, very important in properties. For a will, if you have maybe like 5 houses, 10 cars, blah blah blah, like that, you can write a will. It's simple. When you write a will, it covers your property. Okay, I'm giving so 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 to so 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 so. I'm giving this, my house should be given this, my house should be given to so 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 so, and you appoint an executor for the distribution of your estate. Do you get? And
Yes.
the executor's work starts after the the person dies, the testator dies. The testator is the person that writes the will after he dies. But in trust, the settler appoints a trustee to hold his assets in trust for the beneficiaries. All his assets, to hold it in trust for the beneficiaries, to be managing. There are these people we call trust fund babies.
Hmm. I
Yes.
wish I was home.
A person that manages the assets of the settler. The settler is the person that gives you the right, or gives you the right to be a trustee to his assets. So if you have like plenty stream of income, you have a big real estate business that you want it to be running, you can appoint a trustee for that. A trustee can still be working even while the settler is alive.
All right. Hmm.
So it is to manage the property. Maybe okay, manage this property till maybe Deji clocks 25, you can now give him so 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 so. Or if he marries from so 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 so, do you get?
Hmm.
So Trust covers a wider range than will, but everything you want the trustee to manage to oversee has to be included in the legal instrument you are preparing to appoint that trustee. So anyone that is not included, you can now put it in a will. And for trust, for people that dies even with a will or without a will, you have to still go to the probate registry of each state before you can distribute the assets of that person. But trust, you don't need to go to the probate registry to get any consent.
Mm.
You
Oh,
can, it goes like that. And
yeah.
for will, it is very easy for them to contest will. But for trust, it is it is very hard to
Okay.
contest the trust, because I like the word trust. I trust you with my assets. I trust you with everything I have, to hold it, to manage it, to grow it for the benefit of these people. But an executor of a will is just okay. Oh, this man has money in bank. This man has okay, he's in debt of amount. You pay off the debt. You pay this one. Okay, he said I should give you so. You give the person. But a trustee manage the affairs of the estate, of the assets of the settlor.
Oh, wow. Well, I mean, I don't know if it's really your kind of reference, but I mean, why, if you can't contest a trust, so to say, or it is so difficult to contest a trust, why is it really can't contest it, or why can't you also contest trust? For instance, in the case you also mentioned about how,
Because like a trust now, this trustee starts working immediately after they've signed agreement that okay, I'm trusting this thing in your hand. You get, you will be managing it even before the man dies.
okay,
But a will, okay, I wrote so if you have any issue, you can say, tell the man, okay, oh, this is the issue I have. Maybe as a disowned child, you can say, this is the issue I have. Do you get? But will,
yeah,
um you, it is after the person dies that the executor, that the work of the executor starts. Do you get it now?
okay,
Can you hear me?
interesting. Yes, the network is a bit shaky, but I think I got your
Okay.
point there. Thank you,
And
Barrister Folarin. It's really interesting.
trust is more private, while will, you have to lodge your will at the probate registry. It becomes a public, anybody can go there to ask for. Do you get? But trust is more private.
Okay. All right. Thanks for that. I want to ask in case our viewers want to, because I know you've been giving us some of the things you have been saying so far, things that you learned over the years and your experience. You are kind of getting free consultation here. So if probably anyone
Yes.
wants to get paid consultation now, so to say, how can they contact you? Is it through your social media channel or
You can
is there a phone number
contact
that can be
me
called?
on what?
So, or is there a phone number that can be called?
Yes, you can contact me via my email, ogafolari@gmail.com, on my Instagram, Folari Legal, Folari underscore legal, on Facebook, Oga Folari, and you can also call my number. My number is displayed on all my platforms, so you can contact me through there.
So if in case you want to reach out to her, I mean, we've gotten free consultation here so far. So don't think that it will be free when you go and consult her. You have to pay consultation fee, and obviously you know you're getting solid counsel, you're getting good legal counsel that will guide you right. Thank you, Barrister Folari. I appreciate you. The audience breakthrough is the feedback in the comment section is amazing. Thank you so much for joining, for the engagement and the engagement. I think when you were giving us, people were getting excited. That's why we're happy based on some feedback. So thank you
Thank
so
you.
much for coming around. And I'll still call you some other days. I hope I'm allowed to.
And of course, I'm always here.
All right, thank you so much. So let me leave you to just
Thank you.
continue what you do. It's almost 1 hour already. Have a good day.
All right. Thank you.
Yeah. Thank you everyone for joining this conversation. I'm sure you got value from Barrister Polari. And again, like what we do here is to educate, to allow you to get the best out of real estate investment. So, um, always seek legal counsel, like the lawyer have said. Legal counsel is very, very important. Don't take it for granted. And if you are married, if you are in a marriage, get solid counsel before you do anything now. And don't make assumptions. Assumptions can be deadly, can be, let me know, should I say deadly now? But can be dangerous. So don't make assumptions. Make sure you have a lawyer on your side. If you are doing any transaction, the person, probably the vendor, has a lawyer. You too should have your own lawyer. Every lawyer protects the interest of their clients. So the other vendor does not have your interest. They only have the interest of their clients. And you might get shortchanged if you don't have your own lawyer on your side. So, and Barrister Polari is a lawyer you can always consult. He's an expert when it comes to family law, real estate law, and things like this. So thank you for joining, and I hope you have an amazing day wherever you are or wherever you're watching this from. Have a good day. Bye and see you some other time.